Hello and welcome to the Entrant. The topic for today's discussion is one of the most important under civil laws. Negligence under tort holds great importance when it comes to questions asked in competitive exams. Let us start off by understanding a little about it. The term negligence is derived from the Latin word negligentia, which means failing to pick up. In the general sense, the term negligence means the act of being careless, and in the legal sense, it signifies the failure to exercise a standard of care which the doer, as a reasonable man, should have exercised in a particular situation. The English common law relating to negligence has been adopted and modified by the courts of India on the principles of justice, equity, and good conscience. According to Winfield and Jolowick, negligence is the branch of legal duty to take care which results in damage undesired by the defendant to the plaintiff. Lord Wright states that negligence means more than heedless or careless conduct, whether in commission or omission. It properly connotes the complex concept of duty, breach, and damage thereby suffered by the person to whom the duty was owed. It can be characterized in three forms. Nonfeasance. It means the act of failure to do something which a person should have done. For example, failure to carry out the repairs of an old building when it should have been done. Misfeasance. It means the act of not doing an action properly when it should have been done properly. For example, doing the repairs of an old building but not doing so by using very poor quality materials, creating a major probability of a collapse which would injure people. And malfeasance. It means the act of doing something which should not have been done in the first place itself. For example, using products that are not allowed and combustible to carry out the repairs of an old building, therefore converting the building into a fire trap leading to an accident. The essentials of negligence are duty of care. The duty must be towards the plaintiff. There must be a breach of the duty to care, actual cause or cause in fact, proximate cause, and the consequential harm to the plaintiff. Duty of care. It is one of the essential conditions of negligence in order to hold the person liable. It means that every person owes a duty of care to another person while performing an act. Although this duty exists in all acts, but in negligence, the duty is legal in nature and cannot be illegal or unlawful, and also cannot be of moral, ethical, or religious in nature. In the case of Stansfield versus Strawman in 1948, a decorator was engaged to carry out decorations in a house. Soon after, the decorator left the house without locking the doors or informing anyone. During his absence, a thief entered the house and stole some property of value, which the owner of the house claimed from the decorator. It was held that the decorator was liable as he was negligent in leaving the house open and failed his duty of care. Secondly, the duty must be towards the plaintiff. A duty arises when the law recognizes a relationship between the defendant and the plaintiff and requires the defendant to act in a certain manner towards the plaintiff. It is not sufficient that the defendant owed a duty of care towards the plaintiff, but it must also be established, which is usually determined by the judge. In the case of Donahue versus Stevenson, the principle that we each have a duty of care to our neighbor or someone we could reasonably expect to be affected by our acts or omissions. It was held that, despite no contract existing between the manufacturer and the person suffering the damage, an action for negligence could succeed since the plaintiff was successful in her claim that she was entitled to a duty of care even though the defective good, that is, a bottle of ginger beer with a snail in it, was bought not by herself but by her friend. Thirdly, there must be the breach of duty to take care. It is not sufficient for a plaintiff to prove that the defendant owed him a duty of care, but he must also establish that the defendant breached his duty to the plaintiff. A defendant breaches such a duty by failing to exercise reasonable care in fulfilling the duty. In other words, the breach of duty of care means that the person who has an existing duty of care must act wisely and not omit or commit any act which he has to do or not do. In simple terms, it means non-observance of a standard of care. In the case of Municipal Corporation of Delhi versus Subhagwati, a very old clock tower situated right in the middle of a crowded area of Chandni Chowk suddenly collapsed, thereby causing the death of many people. The clock tower was 80 years old, although the normal lifespan of the clock tower would have been 40 to 45 years. It was under the control of the Municipal Corporation of Delhi, and they owed a duty of care towards the citizens. By ignoring to repair or replace the clock tower, they had breached their duty of care towards the public and were therefore held liable. It must be an actual cause or cause in fact. In this scenario, the plaintiff who is suing the defendant for negligence has the liability to prove that the defendant's violation of duty was the actual cause of the damages incurred by him. This is often called the but-for causation, which means that but for the defendant's actions, the plaintiff would not have incurred the damages. For example, when a bus strikes a car, the bus driver's actions are the actual cause of the accident. Proximate cause. Proximate cause means the legal cause or the cause that the law recognizes as the primary cause of the injury. It may not be the first event that set in motion a sequence of events that led to an injury, and it may not be the very last event before the injury occurs. Instead, it is an action that produced foreseeable consequences without intervention from anyone else. A defendant in a negligence case is only responsible for those damages that the defendant could have foreseen through his actions. In the case of Palsgraf versus Long Island Railroad Company, a man was trying to catch a train and was carrying a package with him. The employees of the railway thought that he was struggling and attempted to pull him inside the train, while the other employee who was on the platform attempted to push him to board the train, causing the man to drop the package, which contained fireworks, which exploded when they hit the rails. The court held that Miss Palgraf was not entitled to damages because the relationship between the action of the employees and the injuries caused to him were not direct enough. Any prudent person who was in the position of the railway employee could not have been expected to know that the package contained fireworks and that attempting to assist the man, the rail car would trigger the chain of events which would lead to Mr. Palgraf's injuries. It must have caused consequential harm to the plaintiff. Proving that the defendant failed to exercise reasonable care is not sufficient. It should also be proved that the failure of the defendant to exercise reasonable care resulted in damages to the plaintiff, to whom the defendant owed a duty of care. The harm may fall into the following classes: bodily harm, harm to the reputation, harm to property, financial loss, or mental harm. When such damage is proved, the defendant is bound to compensate the plaintiff for the damages incurred. In the case of Joseph versus Dr. George Munjali, the Kerala High Court awarded damages amounting to Rs 1,60,000 against a surgeon for performing an operation on a 24-year-old girl without following proper medical procedures and not administering local anesthesia. I hope this video was helpful in providing a simple and clear understanding of negligence under torts. For any further queries, please drop your questions in the comment box below. Please like and share the video and subscribe to our channel.